which I certainly appreciate. Rob, however, kept to his true three-piece suit, sans the tie. So thank you so much for coming.
I won't tell you what else I'm not wearing.
Well, I will call this hearing to order of the Subcommittee on Interior of the Committee on Oversight and Government Reform. The chairman of the Committee on Oversight and Government Reform is Congressman Jason Chaffetz of Utah. I want to thank Congressman Chaffetz for authorizing this hearing and for sending staff from the Washington, D.C. office of the Committee on Oversight and Government Reform to be with us today and assist with this hearing. So your work and your attendance is gratefully appreciated and acknowledged. And I also want to thank Congressman Rob Bishop, who is not on the Committee on Oversight and Government Reform, but who chairs my other committee assignment, the Committee on Natural Resources. So to have Congressman Bishop, also of Utah, come to this hearing is something I very much appreciated. Rob, I'm sure grateful you came up. Thank you very much. We had hoped to have Congressman Mark Amodei of Nevada here today. He was planning on coming until the flu settled in, and he is recuperating, so he sends his regrets. I also want to thank our panel for their attendance today and want to acknowledge their tremendous expertise on a subject that is vexing all of us. That said, welcome to our briefing on the threats to grazing from federal regulatory overreach. This briefing is being held by the Subcommittee on Interior of the Committee on Oversight and Government Reform. I'm sorry. Is this better? Yeah. Okay. Yes. Today the subcommittee's purpose is to hear from folks on the ground about how federal regulations are affecting those who are active on federal lands. Red tape and new rules continue to pour out of Washington, D.C. From water to land use to record keeping to reporting requirements, unelected bureaucrats continue to attempt to impose one-size-fits-all on a nation of more than 3.8 million square miles and 300 million people. This afternoon, we will hear testimony from members of the ranching community about difficulties with grazing and labor regulations. We will hear also from a local official about the struggles local governments face to have their voices heard and to represent their communities. And we'll hear from those who are engaged in legal battles with the federal government to force it to recognize their rights. I hope this briefing will allow members of the panel to gain additional perspectives on changes that can be taken back to Washington, D.C. and make sure government stays out of the way of hardworking Americans. I always find the Wyoming perspective to be invaluable, and I've worked across the aisle with Pat O'Toole during my time in the Wyoming State Legislature, as well as his father-in-law, who I also adored, George Salisbury, whose daughter is also here today. I've also come to truly appreciate the work and diligence of Sean Sims and Karen Budd Fallon. As a rancher and former interim director of state lands and investments, I remain closely involved with the issues of federal regulatory overreach and the challenges everyday folks in Wyoming face when dealing with the burdensome red tape when trying to work with federal agencies. I also thank our other witnesses for making the trek to Wyoming to draw attention to these vital issues. With that, I thank all of our witnesses in advance for your testimony and diligence in putting this together. I know it's a lot of work to prepare for a hearing like this. And I am now pleased to recognize my colleague and my chairman, the chairman of the House Natural Resources Committee, Congressman Rob Bishop of the 1st District of Utah, for a statement.
Well, thank you, Congressman Lemus. I appreciate the opportunity of being here.
I appreciate all of you being here as well. This is indeed something in which we are going to spend more time listening than talking. But it's always good. I appreciate you in your other committee hat on, actually holding and chairing this particular hearing. I'm assuming, I don't know whether you came from your house or your ranch, but it's probably easier for me to get here than it was for you to get here. But I'm grateful for that. We're looking forward to this. I realize, without trying to predetermine any kind of discussion that we're going to have here, that any business, and that includes a business that involves agriculture and livestock, has to have certainty if you're going to move forward. You have to know how to plan. And not that I'm going to say any kind of words come to mind when dealing with some of the federal regulators, but arbitrary and capricious sometimes comes to mind. And indeed, if that is the case, then it's going to be very difficult for anyone to try and plan for the future. And if nothing else, the one thing that we have to develop for the good of people is some kind of certainty, so people know how to plan, what to do. And it's kind of like, I don't think anyone here minds playing the game. You just want to know what the shape of the ball is going to be in which you play. And I hope that's going to be one of the areas in which we have some kind of discussions, is to make sure there can be some kind of ultimate certainty. And if it's not coming from the regulators, then obviously the legislative branch has to move in and try and enforce that. So I thank you for being here. I'm looking forward to the testimony that we're going to hear. Looking forward to any of the comments that may be from the audience, if you're going to have that. But more than anything, I hope this gives us some direction that we can do when we go back in September and start again. With that, thank you.
Thank you, Chairman Bishop, and I'll now recognize our panelists for today's briefing. Karen Bud Fallon of Bud Fallon Law Offices, LLC in Cheyenne, Wyoming. Mr. Pat O'Toole, the owner of the Ladder Ranch in Savory, Wyoming. Mr. Sean Sims, owner and operator of Sims Sheep Company in Evanston, Wyoming. I'm also pleased to welcome Mr. Demar Dahl. Did I pronounce your first name correctly? Good. Commissioner of Elko County, Nevada, and Mr. Randy Parker, Chief Executive Officer of the Utah Farm Bureau Federation. Lady and gentlemen, you will each be recognized for 5 minutes. We don't have a timer except this little device on my wrist. So when I start perhaps waving my name plate, know that you are to wrap up your spoken remarks expeditiously. And I welcome you all, and I look forward to a robust discussion today. Ms. Bud Fallon, you are recognized for 5 minutes.
Thank you, Chairman Lummis and Representative Bishop. I can tell you that as an attorney and as a rancher, we sincerely appreciate your leadership in Washington, D.C. Having worked in Washington a long time ago, it is incredibly frustrating to understand that people who live in D.C. think they understand Wyoming and the West when they really have no concept of what it's like to live out here. One of the most frustrating things that I think that I have discovered in representing farmers and ranchers and private property rights is the fact that it seems like the federal bureaucracy does believe that they know better than we do. And actually, they believe they know better than the Congress about what we need out here. My testimony gives numerous examples of how the federal bureaucracy seems to have created law, not just regulations implementing acts of Congress, but created their own law on how things should be implemented. And so what I want to do is just highlight 3 of those areas of the numerous that I outlined in my testimony, as well as then talk to you about a couple of things I think that would truly help when you go back in September. The first thing I want to talk about is a secretarial executive order that was created by Salazar when he was Secretary of the Interior, 3289. That's an executive order that created what they call landscape conservation cooperatives. A landscape conservation cooperative is not discussed in federal statutes in any way, shape, or form. This was created by the Department of Interior through a memorandum of understanding. Now, the problem with LCCs is that originally it was intended so that the federal agencies would consider things like climate change and science issues and all of those kind of things when they made federal decisions. And that sounds all well and good. But what happened on May 20th of 2014 is that the Fish and Wildlife Service issued a memorandum called a Workload Prioritization Memorandum. And the Workload Prioritization Memorandum stated very clearly that the Fish and Wildlife Service was going to elevate compliance with the secretarial memorandum over and above its statutory duties that were created by Congress. So this Workload Prioritization Memorandum basically said that although the Fish and Wildlife Service is charged with compliance with the Endangered Species Act and listing species and doing recovery plans and trying to get species off the list, the Fish and Wildlife Service was simply going to do only endangered species work that was litigation driven, and then the next priority was going to be landscape conservation cooperatives. Now, in my opinion, the Fish and Wildlife Service should not be prioritizing implementation of a secretarial memorandum that has no basis in law above what Congress has required it to do under the Endangered Species Act. I have attached that memorandum to my testimony. I would point out that the memorandum specifically says, and I quote, the agency, Fish and Wildlife Service, will, and I quote, not carry out the following activities: uplisting rules under the Endangered Species Act, downlisting rules under the Endangered Species Act, monitoring plans, petition responses, proposed rules, or recovery plan revisions. Those are requirements of the Endangered Species Act, and yet the Fish and Wildlife Service is not going to do them and instead going to implement a secretarial memorandum. I believe that is an example of an agency gone totally amok. The second thing that I would point out in my testimony is my discussion of the two rules that were just issued by the U.S. Fish and Wildlife Service regarding the Endangered Species Act. The Endangered Species Act requires that species be listed and critical habitat be designated. And with regard to critical habitat, the Act says that critical habitat is areas currently occupied by a listed species that contain, and I quote, primary constituent elements. And a primary constituent element are things like breeding habitat, feeding habitat, or shelter habitat. The new rules that were finalized on May 12, 2014 now allow the Fish and Wildlife Service to designate unoccupied areas as critical habitat and areas that may develop these primary constituent elements. So you have a huge expansion now of the lands, private property and federal lands, that can be included as critical habitat for an endangered species that the statute never envisioned. Again, I think that is a huge regulatory burden to landowners and to federal lands grazing permittees, because what happens is when an area is designated as critical habitat, even if the species is not there, the take provisions apply. And a take provision, which is prohibited by law, includes adverse modification of designated habitat. So you now cannot adversely modify areas that aren't included, that don't have the species living on them. And what I fear, and I think my fear is valid, is that what's going to happen is now, because of the push of the administration on we are going to fix climate change, the Fish and Wildlife Service is going to look at these lands. They're going to say, well, if we fix climate change, then this land is going to develop primary constituent elements, so we're going to designate it and manage it as critical habitat now. I have to tell you, my daughter works for Congressman Loomis, and I was telling my daughter about this, and she quipped and said, well, how does the Fish and Wildlife Service know where a species may feel like living someday? And I couldn't really answer her question, but that's what's going to happen. The next requirement that I would point out to you is a rule that just took effect on May 11th, 2015 by the Fish and Wildlife Service regarding incidental take statements. And as you know, an incidental take statement is that under which the Fish and Wildlife Service allows the lawful taking of a certain number of species in the course of regularly normal lawful activities. Now, the Fish and Wildlife Service and the Endangered Species Act never includes the word surrogate. You will not find that in the Endangered Species Act at all. But the Fish and Wildlife Service rule now says that it will use surrogates, which are not the species, for an incidental take statement, and it includes an ecological condition as a surrogate. So how is a landowner going to know what is included as a surrogate or not? And those are the new final rules that were issued just 2 months ago. I see that my time is almost up. I would point out that my testimony contains the latest numbers we have discovered under attorney's fees for the Endangered Species Act and under the Equal Access to Justice Act and the Judgment Fund. The numbers are staggering and the litigation continues. I would also ask you to look at the 2 suggestions that I have for reform. One of them is to pass a statute that protects jobs and communities, which I think you could do, that looks like much like the National Environmental Policy Act for jobs and communities. And as I have asked this committee before, I would ask you to consider to apply the Federal Civil Rights Act to federal employees so that federal bullying of my clients and landowners across the nation would stop. Thank you very much.